Hi, good afternoon, everybody. My name's Mark Gracie from Digital Compliance Hub, and thank you for joining this webinar about my framework for ongoing GDPR compliance. I'm going to run through some of the basics of GDPR and the things that are relevant to this particular area, and also look at 10 key things that you should be looking at on a regular basis, and sort of some of the steps that you can take and discuss why you should be doing it. The session's being recorded, so after the webinar at some point I'll send you a copy of the slides and also a link to the recording, so if you want to go over anything again you can do so. I'll also be sending a copy of an associated ebook, and if you have any questions, we'll have a questions and answer session at the end. In your GoToWebinar control panel, you'll see a questions section which you can put in your questions there, and I'll pick those up at the end. The session's booked for about an hour, so I anticipate finishing at 1 o'clock. Might be a bit shorter than that, or maybe overrun slightly depending on how many questions come through. Yes, so let's get started. So my name's Mark Gracie. I run a service called the Digital Compliance Hub, and I've been working with businesses for the last probably close to 2.5 years now, looking at data protection compliance, and obviously GDPR was a key element of that. As part of the Digital Compliance Hub, I'll talk. I provide various different services in helping businesses with their ongoing compliance, but I'll talk a bit more about that towards the end. But let's get started with some of the detail. So let's first of all look at some of the sort of basic elements of GDPR, which leads us on to what ongoing compliance looks like and what you should be doing. So depending on how familiar you are with GDPR and or indeed how familiar you wish to be with GDPR, there's a number of data protection principles or rules. So these set out what you can and can't do with data, and this fan diagram you can hopefully see on screen now has got a set of different rules for different scenarios. So you hopefully be aware of the things like processing has to be lawful, fair and transparent. You should only process the data for the purpose which you've got it. You only process data that you actually need, so you don't collect any personal data that you don't need. You keep it up to date and accurate. You only keep that data for as long as you need it. And the security principle of security, so that's about maintaining the security of personal data, the integrity and confidentiality. But one of the new things that GDPR introduced was a new principle called accountability. In essence, and I've quoted there from the regulation, that basically a data controller, so that's the person who's collecting the data and determining how it's going to be processed, is responsible for and must be able to demonstrate their compliance. So simply put, the accountability principle says it's not good enough that you believe you're compliant, you have to be able to prove it. And we see it throughout the GDPR, whether you're looking at being able to prove that you've been given consent, if consent is your lawful basis for processing, whether you've got documentation because of data protection impact assessments and legitimate interest assessments for using legitimate interest as your lawful basis for processing. These are all elements that are sort of intertwined in the GDPR around the accountability principle. Now, I'm not going to focus specifically on accountability in too much more detail, but it's really at the heart of the GDPR, and it's at the heart of why we're having this session today about managing ongoing compliance. And specifically, when it comes to the GDPR, Article 24 sets out the responsibility of the controller. So again, this is the data controller's responsibility to, in terms of what the GDPR requires. Now, I've quoted there Article 24.1, which is the specific text that is relevant, and I've highlighted in blue, bold underlined, the key words about being reviewed and updated. So what this article in the GDPR is saying is that you as a data controller have responsibility to ensure that you are compliant with the regulation, but that those measures that you've put in place, and these may be technical or organisational measures that you've put in place to ensure your compliance with the General Data Protection Regulation, have to be or shall be reviewed and updated where necessary. Now, there's some challenges around what that actually means, and to be honest, that there isn't much informational guidance as to how to interpret what reviewing and updating means. But essentially, what we're talking about is that the accountability principle says you have to be compliant and you have to be able to prove it. And Article 24 setting out that the responsibility of the data controller is that it's not good enough that you believe you're compliant. You've got to prove it, and you've got to continue to prove it. So looking at this in terms of what this actually means in practice and what you need to be thinking about, well, as I said, that there isn't any clear guidance at the moment around what reviewed and updated means in terms of the GDPR, but it is essentially the concept that it's not good enough that you're compliant on, say, the 25th of May 2018, or that you're compliant today. You need to be able to prove that you were compliant yesterday, last month, last year, next month, or whatever. And I've seen quite a few businesses or people commenting that, you know, GDPR was so last year, it's all about 2018 and being compliant. And what this part of the GDPR and what the regulation is saying is that actually that's not the right approach. The right approach is to think about the data protection compliance as an ongoing matter. So again, the risk of repeating myself, it's about showing that today you're compliant, next week you'll be compliant as well, and being able to demonstrate that. And so the accountability principle requires you to be able to show, should you be at any particular time investigated or having a snapshot or any other investigation, you need to be able to show that you've got everything in place. Now, so the GDPR just basically says in that article, make sure that you review and update your compliance and make sure that you're still compliant. The Information Commissioner essentially reiterates that and says that such reviews should be carried out at appropriate intervals, whatever appropriate intervals might mean, and doesn't go into much more detail. But we do know from some work that the Information Commissioner's Office, the ICO, have carried out, particularly the GPEN sweep study and a charities review. So the GPN sweep is an annual review of basically global privacy across the globe, and the ICO take part in it, and it produces a report every year that sort of sets out the status of things. And this year, 2019, their study was a focus on accountability. And the charities review was something carried out, I think it was April last year, maybe even the year before, which looked at, it was a voluntary audit of some charities, and the ICO basically went into those and carried out an assessment of their compliance. In both the study and the review, one of the highlights is that generally the businesses or the organisations that were involved in the study or the review were able to demonstrate that they were compliant and they were doing all the right things. But one of the things that stood out was that nobody had any clear evidence that they were planning on carrying out reviews or refreshers or anything like that. So it's clearly something that is on the ICO's mind when it comes to the crunch, and if you're going to be investigated, then you'll need to you need to be able to demonstrate that ongoing compliance, and hence why accountability is so important. And in fact, if any of you caught the Data Protection Practitioners Conference, either in person or by watching some of the catch-up videos or online from a couple of weeks ago, accountability was a key thing that was spoken about, particularly in the opening address by Elizabeth Denham, the Information Commissioner. Now, in terms of what this looks like from a best practice point of view, well, my personal feeling is that, you know, it will vary according to your organisation, but generally speaking, probably an annual review will be adequate, and until we get any particular guidance or feelings from the Information Commissioner or even the European group of information commissioners or the equivalents, and the European Data Protection Board, it's up to you really, and this is unfortunately the sort of the vagueness of the regulation and the way it's enforced, is that everything is left up to you until somebody decides that it wasn't perhaps as what you're doing isn't quite good enough, and then you give everybody else gets an idea because somebody's made a decision about what appropriate intervals actually means. But I'd say you should be looking at making sure you're still compliant on an annual basis, and because of what the ICO have commented on and what the GDPR requires, that's about looking at your compliance on a regular basis and putting in place some kind of framework or internal policy that ensures that that's carried out on whatever you determine as being an appropriate interval. But I would say, no less than once a year. And we may see some future guidance, as I said, I sort of alluded to, maybe the ICO documents something in some kind of enforcement action or provides further guidance, or maybe even the European Data Protection Board will do the same. But at the moment, a lot of the work the ICO are carrying out is looking at codes of practice and certifications. These are two elements of essentially governance and accountability that are covered by the GDPR, which is if there are codes of practice that tell you how what the best practice is for carrying out data protection compliance, then you really ought to follow those codes of practice, and you may be accredited via some certification scheme if some exist. Now, there aren't any codes of practice at the moment, and there aren't any certification or accreditation schemes, but the ICO seem to be working towards rolling out various things or being involved in the rollout of various schemes. So, for example, most recently, they've been talking about updating their certification guidance, which essentially sets out a time frame for what they're expecting to happen with the certification mechanism. In the UK, the UK Accreditation Service, or UCAS, will be the lead on that, with input from the ICO, and essentially have an accreditation scheme which is authorised, and you then get some kind of kite mark or certification stamp to prove that you're compliant. Now, the things with codes of practice and certification is that they're typically not mandatory, but they are very cleverly worded to imply that if you sign up to them and follow their practices and their recommendations, then it's in your interests to do so, because you can then demonstrate, well, we're following this code of practice and that's why we're doing what we're doing. So whether we'll see something in this particular area about what reviewed and updated compliance looks like, or even the frequency or what appropriate intervals means, is difficult to say, but it's probably worthwhile keeping an eye on what's happening in the code of practice and certification area when it comes to GDPR, because that might set out a bit of best practice. Now, in terms of what you should actually be doing, sort of the practical side of things, then let's look at what I'm calling a framework for ongoing GDPR compliance. It's essentially 10 sort of headline areas where you can focus your reviews. And as I say, I'd recommend doing this at least once a year. And I'll take you through each of the 10 steps well, not steps, but 10 areas for consideration, each one in turn. And then there's sort of a few bonus bits afterwards. So first thing to consider is reviewing your data processing activities. Now, again, the accountability principle requires most organizations to have documented what data they're collecting, how they're processing it, and things like that. And the detail of that varies depending on the size of your organization. But you should have an idea within your organization what data you're collecting, how you're processing, and what your lawful basis of processing is, for example. And it's worth you looking at that again to make sure that it's accurate and up to date. So what you're looking out for is, has the data changed? So are you looking at a different data set now? And have you carried out appropriate compliance actions against those data? So, for example, are you sure that you're happy with the lawful basis for processing that data? Or indeed that you're now processing different sets of data. So maybe the marketing team has suddenly decided to collect data through a mailing list in a completely different way than they've done before. Or maybe you've got a different HR system in place, and so on. So reviewing your data processing activities is essentially understanding what data you have in your organization, where you're processing it or how you're processing it, and why is it lawful for you to do that. And there's various templates available on the Information Commissioner's website that you can make use of depending on whether you're a controller or a processor, but you want to review that to make sure that you're still processing the right sets of data in the right ways and that nothing has changed, and that will help feed through into some of the other areas that you've got to look at as well. The next area to consider is your internal policies. Now, having, depending on the size of your organization, it might depend on the number of policies you've got or what they cover, but at a basic level, every organization should have a standard understanding documented about what data protection compliance means. And you might have policies around subject access requests and how to deal with those, what to do in the situation of a breach, what to do about IT security and how that impacts on data processing and so on. So you may have a suite of internal policies, but it's important that you look at those and make sure that they're still relevant. And what you're looking for here is basically a comparison between what you believe the law was last time you looked compared to what it looks like today. And probably a year on since GDPR, not much has changed in terms of interpretation of the regulation, but on a regular basis, the Information Commissioner in the UK rolls out various pieces of guidance that changes some things, might change your understanding about some certain aspects or some advice that you were given, or they may enforce certain areas. Now, the enforcement at the moment from an Information Commissioner perspective is very much old data protection because it's all pre-GDPR. So everything that they're enforcing at the moment has occurred before the 25th of May 2018. So we don't have any clear steers around anything that might change, but having these enforcement notices and these enforcement actions, which they publish on their website, may give you some steers in some changes or different ways of implementing things. And we've seen this over the last 20 years or so. Is very often it's sometimes sector driven, but say a sector has been doing some kind of processing which the whole sector is doing, only to find out that it was unlawful, or the Information Commissioner has declared that it's not as the way that they think it is. And that kind of sets a precedent which you then may have to adapt into internal policies. So that's why you need to look at your internal policies. But as I say, probably the good news, I guess, is that your policies probably won't have changed very much between what they look like. So I looked like when you implemented them maybe a year ago, or in whenever you decided to do your compliance program, compared to what the guidance and the regulation sets out now. Excuse me. But it is worth paying attention to those enforcement notices, and it is worth just reviewing any changes in guidance that have come out. So the ICO have published various bits of guidance, so they've got more detailed information about legitimate interest, for example, and they're continually rolling out stuff. Just as I was saying about codes of practice and certification, these are things that change, and if they affect your organisation and the way you do your compliance, they're going to affect your internal policies, which you need to review them on this regular basis, or at least once a year. And even if you think that nothing has changed, it's worth documenting in some kind of document control that you've reviewed it, because if the evidence is that you're relying on a policy decision in terms of what you do with your data, and you get questioned about that, you can say, well, we checked it 6 months ago, and that's when we did our annual review, and it showed that we didn't think anything had changed, so we must have missed that, and that might help in terms of you demonstrating your accountability and your compliance with that element of GDPR. And on the subject of policies, the other thing you need to review is your privacy policies, and you should have you should have at least one. You might have multiple ones depending on the data subjects who are impacted. So some organizations, for example, will have a privacy policy on their website that talks about what happens if you interact with the website. They might have a separate privacy policy for their customers, or they might have a separate privacy policy for their employees. No matter how many you've got, you should look at them, and for the same reason you're reviewing your internal policies, you should be looking at your privacy policy and just making sure it's accurate and up to date. And of course, this goes back to the first one, which is if you've identified different sets of data or changes in the way you're processing data, you need to make sure that your privacy policies reflect that, so that the data subjects that maybe you've identified new ones, can look in the privacy policy and say, oh yes, that's me, and therefore this is what happens to my data, and they can understand it. And the privacy policy is important. It helps meet the requirements of the right to be informed. So that's about telling the data subjects, the people whose personal data you're processing, why you've got their data, what you're doing with it, why it's lawful for you to process it, and so on. So just like reviewing your policies, you need to review your privacy policies. Moving on to the next thing, you might have, it's all well and good having internal policies and having a good understanding of data protection, but you need to make sure your employees are up to date and still reminded about the importance of data protection in their day-to-day roles. Now, that's not suggesting you need to all send them all on an annual, all-day course that's, you get a certificate at the end. It's about maybe a 2-3 hour session explaining to them about the basics of data protection, taking answers, particularly if they're reflecting on how data protection applies to what they do. But it's about making sure that employees are reminded that data protection is still important and what that actually means in a day-to-day basis for your organization. So you should be looking at your refreshing your employees' training, rolling out some kind of way of just sort of re-educating or reminding your employees about the importance of data protection. And you should also take it as an opportunity to just look at what happens to new starters, because if you've not done any training since, say, May last year, and you've taken on new employees, well, what training have they received to make sure that they're complying with your rules around data protection and what you do, and making sure that they understand? So, if you've got an onboarding process for new employees or a new starter system that you use, then make sure that that's got up-to-date data protection compliance information in it to make sure that new starters are actually getting the data protection training as part of their onboarding, and also make sure it's up to date as well. So that's policies and employees, and making sure everybody is on board with data protection compliance. And just one last thing on the employee factor. If you need to be able to show that your employees understand data protection, because on a day-to-day processing of data point of view, and you're going to have some teams or departments that possibly process data more than others, but if your employees are getting it wrong, then from a compliance point of view, you're going to be getting it wrong as an organization. So investing time and energy in making sure you've got your internal policies right, and that your employees understand what those policies actually mean on a day-to-day basis is a key part of demonstrating your accountability, and that you're taking that accountability principle seriously. The next thing to consider is your third-party processors. Now, bearing in mind that there's a wide definition of processing, and that means that anybody who's doing anything with your data on your behalf, and that covers from a third party who you're asking to do something with specifically for, right across the piece with storing, because processing covers editing, deleting, manipulating, storing, sharing, and so on. You're probably using third-party processors across your organization in different ways. So, for example, if you store your personal data in an Excel spreadsheet and you store it or allow your colleagues to share it via something like Dropbox or Microsoft OneDrive or Google Drive, those third-party storing providers, Dropbox, Google, Microsoft, are third-party processors. If you're using an online customer relationship management CRM system to store your contacts or your marketing database or whatever, then if that's cloud-based, then they will be a third-party processor. So hopefully you've already done this, but you should be looking at what third-party processors you've got and making sure that you've got the required pieces in place. And Article 28 of the GDPR basically says two things. Don't use a third-party processor unless they're GDPR compliant, because if they're not, then you won't be. And very specifically setting out the terms of such agreements, it says you have to have a contract in place. So if you're a data controller, you need to make sure there is some kind of data processing agreement, sometimes called a DPA, or a contract in place that basically sets out the rules about the processing of the data. And that will vary depending on, or the approach will vary depending on how proactive the processor is or how proactive you are. But in essence, you should be, as part of your annual review, looking at what third-party processes are we using? Have we made sure that we've got everybody documented? You know, have you introduced new ones which you've missed or you've not carried out the due diligence on yet? And have you got agreements in place with those? But also, who your existing ones are? They still existing? Is the data processing agreement still up to date and not being changed? Because you might find that, in theory, a data processor, if they change their own data processing agreement, which you've signed up to by using the service, they should have told you about that. And you just want to double check that everything's still compliant, or make sure it doesn't have any other extra impact on what you are doing with the use of their service. So look at your third-party processors. As part of your documented data processing activities, you should have a good idea of who those third-party processors are. Make sure they're actually truly reflective of who you're using, and make sure you've got the right appropriate contracts and agreements in place to meet the requirements of Article 28 of the GDPR. And continuing on the theme of documentation, data protection impact assessments. The GDPR requires these in very specific circumstances, like if you process what's referred to as special category data, so things like biometric data for ID purposes, medical records, trade union membership, ethnicity, and those kind of pieces of data. But the Information Commissioner has essentially said, whilst the GDPR requires it in a very specific area of your processing, the ICO maintains what it's maintained for quite some time, because the concept of a privacy impact assessment is something the Information Commissioner introduced some time ago under the old data protection regime. They basically say you should carry out a data protection impact assessment whenever you decide to do something new with data, or introduce a new system or process or new project or new service. So you should have carried out data protection impact assessments, and as part of your review, have a look to make sure that they're still current. If you've got some risks, make sure that those risks are still covered off and are mitigated, because a data protection impact assessment is basically a risk assessment of your processing. So you identify the risks of the processing and the solutions to mitigate them. So it's worth looking at what those risks were that you may have identified, if you indeed identified any, and make sure that they're still being mitigated and that nothing sort of slipped through the net. So it's about just understanding your data protection impact assessments and your documentation across the piece here is still accurate and up to date. It's also worthwhile just checking where your data is being processed, and this should come out from understanding what data processing activities you've currently got, you're currently carrying out, as well as things like reviewing your third-party processors. Now this is key, and I put Brexit with a question mark in brackets, and apologies for raising the Brexit word, and particularly since it's gone a little quiet in the media just of late. But you know, Brexit could have an impact, and it's worth you just checking what impact Brexit could have on your data processing activities, particularly if you're processing data on behalf of other parties, or you're passing data in and out of the UK. But just check to make sure that particularly third-party processors are not suddenly processing data in a different place, or that you're not storing data somewhere differently, or things haven't changed in your organization. Because over the last year, so many different things could have happened. You might have been acquired by another business, or you might be working with different partners. And if you're, you know, if you've got the right checks and balances in place that allow the sharing of data between different parts of the organization or whatever, then you might be not having spotted that data is now being processed in a different part of the business, in a different part of the world. And so it's worth checking where your data is being processed, and make sure you apply the rules around non-EEA data transfer, which basically says you can't process data outside Europe unless you have appropriate checks and balances in place. So it's things like, you know, checking the sure that the privacy shield is still relevant, checking that the people you're using who are relying on privacy shield because they're US based are still signed up to privacy shield, and so on. So check where your data is being processed. Just be mindful of what impact Brexit might have on your data processing activities, and particularly when we do leave, and if there's a no deal Brexit in the end, whenever that may be, then that might be something you might have to do a little bit quicker than you would normally need to do if we go out with a withdrawal agreement. Yeah, so yeah, check where your data is being processed and just make sure you've got all the right checks and balances in place with regards to that, and if anything has changed. And check anything else that you've got that is documenting and evidencing your compliance and that you meet this accountability principle. So have a look at your consents and make sure that you still got documentation that people have given you consent and under what circumstances. Check that your marketing team are still using the right GDPR compliant consent mechanisms, that they've not accidentally snuck in pre-tick boxes or not making references to privacy policies and so on. Check and go through your subject access requests and register in your breach registers, just to reflect on some of the challenges you faced over the last year, and also to make sure that they're being documented and that they're an accurate reflection of what's happened. Because if there's things that has happened but they're not documented, then there's some part of the process isn't working and you're not documenting everything. So basically look at your documentation. Just very quickly on the consent thing, it's something that cropped up a lot last year in the lead up to GDPR coming into force, which was, how regularly do I need to renew consent? Well, that's something that you ought to be looking at in terms of this review. It depends on the circumstances. If you've got consent to have people on an email list for marketing purposes, and they've always got the opportunity to unsubscribe, which they should have. If you're using the list, you need to provide an unsubscribe capability to enable people to withdraw their consent. But so you could argue that that's probably okay, because people have always got the opportunity to remove consent once they've consented to join your list. But if you're relying on consent as the lawful basis for processing in other areas, then you might need to look at what the Information Commissioner is saying at any particular time about what renewing consent might be. And certainly last year they were talking about that depending on the circumstances, it could be that they would accept up to 2 years for refreshing consent. So these are the kind of things you need to look at, which is why, as I mentioned before, about looking at internal policies and the ICO's enforcement notices and the ICO's guidance to understand what has changed and what you need to look at. This is a key area here, that if the ICO doesn't suddenly decide that consent should be reviewed at a very specific hard point in time, then you need to make sure that you're looking at those kind of things as well. So check out anything else that you're up to in terms of documentation and meeting the accountability principle. So on to sort of the penultimate one. The last one's a quite straightforward, easy one, you'll be pleased to know. This one's slightly controversial because it's not something that is necessarily going to be easy to achieve, and it's going to possibly be resource heavy. And I know from organisations that I work with that the thought of spot checking compliance is sort of putting unnecessary burden for scenarios that may or may not ever happen on employees who are already sort of maxed out in terms of what they're doing. But you might want to think about, how can we check that certain processes and procedures that are internal to your organisation are actually working when it comes to data protection compliance. So the thing I always say when I talk to people about this is that if you're maintaining a list of data breaches, for example, and the team around you are telling you if a breach occurs, then you know that a breach has occurred, and that element of compliance is being addressed internally because people are talking to you about it. If they're not talking to you about it, does that mean that's because no breaches are happening, or is it that breaches are happening, they're just not telling you about it? In which case, that element of the compliance, internal compliance process and policy isn't working. So it's a bit like saying, you don't know what you don't know. And a spot check of, running a sort of a test scenario breach situation or a test subject access request may bring up or highlight some areas of the process and policy that's not working. And if you have a fake customer you can use that you pretend to be a fake customer and you serve a subject access request and you never get anything back, or if you're the person responsible for data protection and you've never been engaged so to be told about it, then something's not working somewhere. So spot checks have a place, and some kind of sort of mystery compliance shopping, I suppose, is another way of looking at it, then it can be very beneficial in sort of highlighting some of the areas that are not working so well, or that you might have some challenges with, and it might bring up some of the areas that you ought to be being told about, but you're finding you're not being told about them. But as I say, I'm fully mindful that for some organisations it's a bit over the top, or not easy to do because of the potential resource implications. And then finally, in the sort of 10 things to do, a very simple one, but an important one nonetheless. Check your ICO registration. So the Information Commissioner's Office requires most data controllers and processors to be registered. There are some exemptions. There's been a difference and a change in the mechanism. So under old data protection, we had to be registered if you were processing data and explain what that processing activity was, and you had to pay a fee. Under the GDPR, there's no such regime in place, but the Information Commissioner needs to be funded some way, because contrary to popular belief, they don't get funded by the fines they issue. So there is a data protection fee, which was introduced by a new piece of legislation that came in at the same time as GDPR and the Data Protection Act 2018, which essentially says if you process data, unless there's an exemption that applies, you have to be registered with the Information Commissioner's Office. And the fee structure has changed, so the fees are slightly higher than they were before, and there's different levels depending on the size of your organisation, and those will determine how much of a fee you pay. Now, it may seem an obvious thing, but things happen. Employees who are the registered contact for ICO registration have left the business or away, or that the ICO's email that says don't forget you need to register under the new scheme, or even the scheme in terms of renewal gets missed or gets filed in a junk folder somewhere. If you just simply have to go to the Information Commissioner's website, there's a link on the right hand side at the top about data protection fees. You can go to that, search the registry. If you can't find yourself, see if you can find the registration renewal. Have a look at when you think you're due for renewal, but the bottom line is sort that out and make sure that you are registered, unless there's an exemption that applies. And there's various tools that the ICO provide that enable you to sort of understand whether that's the case. Now, as I say, it seems quite a simple thing to do, but I know from working with various different organisations that, you know, unfortunate things happen, like employees leaving and the renewal email going sent from the ICO to the employee that's left. Nobody else thinks to think about it. You assume it's all done, or you're registered, and it turns out you're not. Those are the kind of things that could land you with a few £1,000 fine if you should be registered and you're found not to be. I haven't heard much news about it recently, but in the last year or so, the ICO has certainly made a lot of noises about the fact that they've, almost on a sector by sector basis, been chasing down organisations who were registered under the old scheme and no longer registered, and probably ought to be. So they get given a time frame in with which to comply, and they're pretty flexible. So if it turns out you've lost the email, you never saw the email, or the employee who used to receive the email is no longer there, and you suddenly realise you're not registered, just get in touch with their data protection fee helpline, which is through their main helpline number, and they'll send you, you probably have to do some sort of security checks and stuff, but they'll send you a new email with a link on how to renew, and you can get it done and dusted there. There's no suggestion, or I've not seen any suggestion from the Information Commissioner that you'll get penalised if you realise that your renewal was missed and that you should have been registered 6 months ago or whatever. I obviously add the caveat there that that's, you know, they've not been publicising anything around that kind of detail. The key thing is that you're registered, so that might change. But yeah, definitely speak to them if you're not registered, because there's a good chance you might get spotted and get yourself into trouble if you aren't. So those are the 10 key things. Moving along, some extra things you might want to think about. Make sure someone in your organisation is taking responsibility for data protection compliance. If you're mandated to have a data protection officer, that should be a data protection officer, and they should be doing all of these 10 things and probably a lot more to ensure that you're still compliant and continue to be. Otherwise, make sure that somebody, you know, if you're the head of the business and you've taken on that responsibility, well, I'm afraid that's your responsibility to look at how do you do all of these things. and so on. But if there's somebody taking responsibility, then these kind of things aren't going to be missed. Things like ITO registration, making sure you're reviewing and stuff won't get missed. So it's really important, even if you're not mandated to have a data protection officer, to have somebody who's taking responsibility, and take it as an opportunity, particularly if you're the individual who is the responsible person for data protection compliance, to carry out the review and produce a report for senior management team. Give them an update, explain to them the kind of work that you've been carrying out over the last year, as well as the fact you've checked that you're still compliant. And I think that speaks volumes in terms of the effort that you're probably putting into this, and making sure that the organisation fully understands the importance of data protection and why they've got you doing what you're doing. And the other thing to do is, if you can, continually, and I talked about employee refresher training, but if you can continually raise awareness internally through briefings or internal communications in newsletters, or however you communicate with your employees on a regular basis, then that's going to be really helpful as a way of demonstrating you're maintaining compliance all the time, and you're reminding your employees that they need to think about third-party processes they might want to start using, or that they need to worry about what the breach protocol is, and so on. So look at whether you could issue monthly or however frequently you see works within your organisation briefings to keep the data protection compliance ticking over in everybody's minds through whatever mechanism works internally for you. So those were the key things I wanted to cover. I just briefly, I want to leave plenty of time for Q&A. We've got about 15 minutes left, but I just briefly wanted to sort of do a minor sales pitch and talk about the Digital Compliance Hub. So the Digital Compliance Hub is a service I operate, which provides various different levels of support, but essentially helping businesses with their GDPR and data privacy and data security compliance. And I kind of offer that in three different ways. You can either subscribe to the Digital Compliance Hub, which is a support when you need it service. So there's a telephone and email helpline, and that's backed up with a library of resources and toolkits. So, for example, and I'll talk about some of the Hub's resources available for ongoing compliance in a second. But for example, there's an ongoing compliance section, and you can use those resources to help guide you through what we've been discussing. But you can outsource and have a data protection manager doing the compliance for you, or you can pay as you go for sort of ad hoc support. And the kind of stuff that's available through the Hub subscription is documents and policy templates, through to compliance reviews, alerts and updates, training. But the key thing is it's support, and you're getting the help when you need it most. And on the subject of maintaining your compliance, I mentioned the ebook at the beginning, and I'll send you a link so you can download a copy. It essentially summarizes what we've covered this afternoon. But there are other tools and information available to Hub subscribers. And something that I'm working on at the moment is an ongoing compliance kit. So it's essentially a roadmap that leads you through everything we've discussed in a bit more detail. So you've got some checklists to work through, supporting documents and so on, such as a framework template, so you can have an internal process document, so you can show that if you should ever need to the regulator that, well, we have an internal policy that says once a year this person will carry out all of these duties and so on. So if that's something that you are looking at, or you're thinking about, well, this is all very well and good, Mark, going on about all of these 10 different things we should be looking at, but that's a heck of a lot of piece of work, and we thought it was all over and done with last year. Well, I'm sorry, it's not. It is, GDPR compliance is about maintaining compliance, and until the law changes, maybe in the next 20 years, you need to worry about data protection on a regular basis. If you're looking at all of this and thinking this is a lot of work and I need some help, then get in touch and let's have a chat about how I can support your organisation, or even the person that's taking responsibility for all this in what they're doing to maintain that compliance. So I want to hand it over now to Q&A, and if you've got any questions, as I said, in the Go To Webinar control panel, you should see a questions tab. And if you type your questions in there, then we'll pick them up now. There's nothing there as we've been going, but I'll give you a couple of minutes. I'll just grab a drink while you're doing that to ask any questions. if nothing comes through, then I'll say that's the end, and we'll finish it there. That's a good, a nice question. Thank you, Stephen. How much does membership of the hub cost? So the basic help and support advice line backed up the library resources is 125 plus VAT a month. That gives you unlimited web and email and phone support. So you can use it to either get specific help in a particular area, or if in an emergency scenario you've got a subject access request which is proving difficult, or a breach issue and you want to try and work out whether it's something you've got to report, then that kind of help and support is available. And the library of resources is growing month by month. We add as much as we possibly can to help support you sort of in the background. So yeah, 125 plus VAT a month. And the other elements of services cost obviously various different things depending on what you need. Okay, any more questions? Got a few thank yous, so thank you for those. Okay, so a question sort of more specific within GDPR about any key tips for responding to subject access requests. Well, I suppose the key things are to understand what it is that you're supposed to do when you get a subject access request. So if you're not sure what I mean by subject access request or an SAR, but sometimes people refer to them as a data subject access request or DSAR, they're essentially one of the individual's rights that the GDPR has, and it's one that's been around for data protection laws since the old Data Protection Act in the UK came into force, is a right to understand what data an organisation has on you, what they're doing with it, and why you've got it, and what you're going to be using it for, and also to provide a copy. So if I'm honest, a lot of subject access requests are usually in a scenario where people are slightly disgruntled, and it might be an employee that you've had to let go, and then they suddenly serve you with a subject access request wanting a copy of their employee file and those kind of things. But there's not always the case. But essentially it allows a data subject to ask for a copy of their data and details about how it's being processed, and there's a few other things the law requires you to say. So the key things are you get a month in which to reply to it and respond to it. You should respond to it as soon as possible. Don't leave it to the month just because you can. You should deal with it as quickly as possible. You have very little choice. There are some exemptions. There's some exemptions in employment law that mean you don't have to disclose everything from an employment perspective, but generally speaking, most information is disclosable, and you have to, as I say, you have to do it in a month, and you have to do it for free. You used to be able to charge. You can't charge anymore, except in very extenuating circumstances. So the key thing is, by understanding what data you have around your business, understanding the key employees within your business that can help you find the data when you get a subject access request, those are the key things, because you need to be able to pull that data together within a month, and you have to supply it to them. But in terms of the process, have a data subject access request policy document which sets out for the rest of the business an understanding about what they're expected to do if they get one, right down to what you may be doing if you're the person that's been designated to deal with them. And also in terms of talking about it as part of your employment training, think about how do you get across the message that everything that is documented will fall within a personal data record for a particular person, and therefore if you I've spoken to businesses before, they have customer service systems, and customer services representative writes something derogatory about the person they've just been talking to in the notes. Well, if that person as a customer serves a subject access request on that business about his customer service record, those notes would be disclosable. So it's about educating people as well about the fact that you're raising awareness that everything is disclosable, and there's nothing you can do about it. If you want to go down the route of trying to not disclose stuff that you don't want to disclose, then you can do that. But if you get caught out and it goes to the Information Commissioner for investigation, then the Information Commissioner is going to want you to explain why you didn't disclose the data. And there's plenty of case studies around about where that's happening across Europe, of people being caught out by not responding to subject access requests in time or at all. So I'd say, in short, a key tip for responding to subject access requests is you're going to have to deal with them and make sure you've got an internal process and policy, somebody taking responsibility to deal with them in a timely fashion, and make sure that everybody across your business understands, even if they're not responsible for dealing with them, they understand the concept and the requirements that you have to deal with them. And that's why, actually, going back to my 10 areas in the framework, you should carry out spot checks, because you might find that employees are receiving subject access requests, but they don't recognize them as such, and so they're not finding their way to you, and therefore they're not being dealt with. And that's where enforcement action starts rearing its ugly head, because they might be going to the Information Commissioner and saying, well, I served a subject access request and I've not heard anything, and it's been 2 months or whatever, and the ICO will start investigating, asking questions. So I hope that answered your question. I don't know if you had a specific question, Stephen, about subject access requests in general. Here's a good question. Do you predict an increase in subject access requests when things like PPI claims die down? Firms doing these kind of things need to replace their income somehow. I'm kind of paraphrasing. Could they use it as an excuse to trawl a customer's records for looking for anything, little thing that is used as an excuse for look for compensation? Well, the key thing with subject access requests, I guess carrying on the answer to the previous question, is that you can only disclose the data to the data subject. So if you're disclosing data to a third party, be they a CMC or a PPI firm, then you need the permission of the data subject to do that. So no, I wouldn't say that subject access requests are going to be on the increase as people looking for ways to channel compensation may rise. Subject access requests are unlikely, because the organisations themselves are not likely to be able to do that. That said, if those organisations are reaching out to data subjects who are impacted in one way or another, and we're certainly seeing this from a data breach point of view, then yes, I suppose they could be increasing the number of subject access requests, because that might be one of the things that the lawyer or the company helping the individual with some kind of compensation claim might be suggesting that they do that. I think the thing with subject access requests is that, and I always thought that we would see a mass increase in subject access requests after the end of May last year, because as well as so much education and awareness about GDPR occurring because of waking businesses up to the idea that they need to worry about data protection, and for the first time or again in the guise of GDPR, it was also educating the general public to suddenly realise, hey, I can ask for my data without having to be charged £10 plus VAT, which was always a good way of cutting down the number of subject access requests. But I would say from the businesses I've been working with, I think there was a small peak of people using subject access requests to get access, but in a general sense, I don't think it's been a mass explosion as everybody thought it might be. But who's to know? It could change. Now, in terms of the compensation angle, what I have seen, and if anybody follows my blog, I've certainly blogged about it, is that there are very public announcements about breaches and data breaches, and there is an indication that some law firms particularly, are targeting the data subjects who are impacted by those breaches to claim compensation or damages on their behalf. And the GDPR does allow that as some form of compensation. So whilst the individual organisation may be investigated by the regulator to see why a breach occurred, and there are regulations that set out what you need to do in the scenario of a breach, there is also one of the remedies is that if a data subject can prove that they've suffered some kind of damage or harm, and that may be financial, physical, or mental, or any other kind of harm, that they can claim damages against the organisation as well. And I've certainly seen some law firms pursuing some significant breach incidents, looking for data subjects who have been impacted so that they can basically pile a lawsuit together against the organisation that suffered the breach. So yeah, so we may see more of that, and maybe a knock-on from that is an increase in subject access requests, but it's difficult to say really. Okay, well, I think I've answered everybody's questions that have come through. I'll give you a couple more seconds if anybody else has got anything else to ask. Otherwise, we'll leave it at that, and thank you very much for your time. Okay, well, thanks for the thank yous that are coming through. Right, I take that as no further questions. So thank you very much. I hope that you found that useful, and good luck with your ongoing GDPR compliance. Enjoy the rest of your day.